If you decide to proceed with divorce, there are 4 steps that you need to take. Step 1. Plaintiff files the originating summons. Step 2. Mediation. Step 3. Pre-trial conference if there is no agreement. Step 4. Hearing. As the plaintiff, you are required to file an originating summons within 6 months from the last counseling date. You will receive a letter from a counselor indicating the documents you need to submit to the Sharia court, whether in person or through your lawyer when filing the originating summons. They are identity card or valid passport, original or extract copy or certified true copy of marriage certificate or revocation of divorce certificate, children's original birth certificates, latest CPF statement showing the public housing scheme withdrawal details, latest CPF statements showing the balance in your ordinary, special, Medisafe, retirement and investment accounts, returned CPF standard query reply, applicable for CPF members aged 55 and above only, returned HDB standard query reply, applicable to HDB flat owners or occupiers only, latest HDB statement on outstanding mortgage loan, or latest bank statement on outstanding mortgage loan, latest property statement applicable to private property owners only, agreed or proposed parenting plan form if you have children below 21 years old, agreed or proposed matrimonial property plan form if you have an HDB flat, completed case statement. A filing fee is applicable for the filing of the originating summons. If your documents are incomplete, you will not be able to file the originating summons. Please ensure that you have checked against the letter for the documents required before you come for filing. One of the forms required by the court is the case statement. You must fill in every section of the case statement. The case statement provides the court with information on the grounds for divorce as well as the ancillary claims such as nafkah iddah, muta'ah, custody of children, and division of matrimonial property. Nafkah iddah is the maintenance given by the husband to the wife during the iddah period. The wife is forbidden to marry another man under the Muslim law during the iddah period. Muta'ah is a consolatory gift that is paid by the husband to the wife upon the divorce. There are 3 terms that you should know pertaining to the order on your children. Firstly, the parent who has custody has the authority in making major decisions such as education, religion, and health matters. Secondly, care and control determines which parent the children should live with. Thirdly, the parent who is not given care and control of the children is given access to them. The court may make orders to divide the matrimonial property, such as the transfer of CPF monies, or for the matrimonial property to be disposed or divided. You should therefore consider what to claim and how much to claim. You will also be required to indicate your proposals in the agreed or proposed matrimonial property plan. Upon the successful filing of the originating summons, there are 2 ways in which the plaintiff can choose how the originating summons may be served. They are by way of personal service or registered post. The originating summons must be served within 12 months from the date of its issue unless its validity is extended by an order of court. As a plaintiff, if you have chosen to serve the originating summons by personal service and have provided a local residential address of the defendant, the Sharia court will send a letter to inform the defendant that you have started divorce proceedings at the Sharia court. The defendant will be required to come to the Sharia court to receive the originating summons in person. If the defendant does not collect the originating summons in person, the court will attempt to serve the originating summons at the local residential address provided by the plaintiff. As a plaintiff, if you have chosen to serve the originating summons by registered post, you must ensure that the documents served on the defendant are complete. The defendant will then be required to return the acknowledgement of service form to you. After you have received the acknowledgement of service form from the defendant, you must then file the acknowledgement of service form in court. If the acknowledgement of service form is not filed by the plaintiff, the service of the originating summons will not be effective, and the plaintiff will be required to file an application for a substituted service. If personal service or service via registered post is unsuccessful, or if the defendant's whereabouts is unknown, the originating summons must be brought to his or her notice by alternative methods such as newspaper advertisement, registered post, or via email. You will be required to file an application for substituted service. The purpose of the application is to seek the court's permission to serve the originating summons via the selected mode of service. Upon being served with the originating summons, the defendant is required to file a written statement called the Memorandum of Defense within 21 days after the date of service of the originating summons. The defendant is required to provide the court with the following documents: latest CPF statements showing the balance in his or her ordinary, special, MediSafe, retirement, and investment accounts. Returned CPF standard query reply, applicable for CPF members aged 55 and above only. A filing fee is applicable for the filing of the Memorandum of Defense. Upon the successful filing and service of the originating summons, you and your spouse are required to attend mediation together. The defendant must file the Memorandum of Defense before the mediation date. If you have engaged a lawyer, you will have to attend this session with your lawyer. The mediator will discuss with you and your spouse to see if an agreement can be reached on the divorce and ancillary matters. If there is an agreement and the court accepts the agreement, the divorce may be heard on the same day. If there is no agreement, the matter will be referred for pretrial conference. At pretrial conference, or PTC, the court will direct parties to file the necessary documents and information in court to prepare for the hearing of your case. If you have engaged a lawyer, your lawyer will attend PTC on your behalf. You will be given a hearing date only after you have complied with all directions of the court. At the hearing, the court will decide on your case based on the evidence that you have submitted in your affidavits. You must be present, and if there is a dispute on custody, care and control of your children between 7 and 21 years old, they may be required to be present as well. In some cases, the court may require witnesses to give evidence on your behalf. The court may refer your case for arbitration in some circumstances. The purpose of arbitration is to effect reconciliation if possible, or to advise on an amicable divorce. After the arbitration, the arbitrators will provide a report to the court on whether the divorce can be ordered. Payment is required for the appointment of arbitrators. For more information, please visit our website.